They fired my union wife illegally. It cost them her job back, plus all lost wages. Welcome back to Reddit Court Files, where we pull real stories from Reddit and put them on trial. Today's case comes from r/Antiwork. Quick note, nothing in this video is legal advice. We're storytellers, not lawyers. Now let's get into it. My wife, a dedicated union worker at the Clerical plant, suddenly found herself without a job. She was wrongfully terminated, all because local management decided to completely bypass the standard collective bargaining point system. Their method? Inventing a conduct charge on the floor over what was, by all accounts, a protocol-compliant call-off. The facts were clear, undeniable. Security logs explicitly showed she called in before her shift, stating she was tardy because she was out of PTO and providing a definitive return date of NSD, her next scheduled day. A perfectly legitimate, transparent communication. Yet management twisted this into a reason for dismissal, fabricating a narrative to fit their agenda. They logged it as a simple tardy, but then, with baffling audacity, they rewrote history 3 days later on a progressive discipline form to process the infraction as an improper call-off, a conduct violation designed specifically to bypass the union's point bank system. Then, they flipped the script a third time on the formal corporate notice, officially documenting her separation as general absenteeism under the hourly attendance policy, completely ignoring the mandatory progressive steps required by the contract. This wasn't just unfair, it was a deliberate 3-stage assault on her employment, mutating a simple tardy into a termination for absenteeism through increasingly convoluted lies. And the cost of their administrative negligence? Not only her job, but also her state unemployment benefits, which the company actively kept in total administrative limbo, essentially trapping her without income while they struggled to concoct a consistent story for the Department of Labor. The strategic landscape completely shifted when both the plant manager and the union president were finally forced to admit the truth. My wife was fundamentally wronged, and the initial attendance policy interpretation was completely botched. This was a critical concession, a victory in itself against the initial stonewalling. However, despite openly confessing to their error, the company was still floating a standard, low-ball compromise. They offered her preferred shift layout back, but completely refused to pay a single cent of back pay for the time missed due to their own administrative negligence. It was a classic corporate tactic, admit just enough to appear reasonable, but claw back on the actual financial consequences. This penny-pinching tactic, however, made perfect sense when you looked at the severe financial strain trailing the parent organization. Global law firm Jones Day was aggressively suing the private equity parent firm and its glass portfolio brands in New York Supreme Court for $9.6 million in unpaid legal bills. Court filings in that case explicitly detailed a corporate culture of serial false promises and financial manipulation, including an executive directive to draft a fictitious funds flow document to mask their delinquency. If a multi-million-dollar corporation is literally dodging a $9.6 million bill to the high-powered lawyers who defend their plant operations, it became entirely obvious why local management was executing desperate backdoor maneuvers to cheat a frontline worker out of a few weeks of earned wages. The fight wasn't just about my wife's job anymore. It was about exposing the systemic rot. The company was stalling their responses to the state regarding her unemployment because entering these contradictory, fraudulent internal documents, logging it as a tardy, processing it as an improper call-off, and finalizing it as absenteeism into a state regulatory system crossed directly into misrepresentation territory. They knew they were caught, and the legal implications for them were severe. Ultimately, my wife made a tactical decision for our household. Faced with the immediate need for income and shift stability, she chose to accept the company's offer of her preferred shift layout back. But let's be absolutely clear. This was not an absolution for their corporate negligence. This was a strategic move to secure our family's immediate future while the full picture of their wrongdoing was laid bare. The company, under pressure, had been forced to admit the wrongful termination and offer her job back. The true victory, however, lay in exposing their tangled web of deceit. When you tracked the literal paperwork they generated from the morning of her absence to the final termination notice, they had produced 2 entirely different conflicting reasons for discharge on official letterhead. They logged it as a tardy, processed it as an improper call-off, and finalized it as absenteeism. Their inability to tell a consistent story to the Department of Labor, their fear of entering contradictory, fraudulent internal documents into a state regulatory system because it crossed directly into misrepresentation territory, this was their undoing. They couldn't maintain the lie under scrutiny. So while the company dodged the back pay, they were forced to admit error, reinstate her, and in doing so, publicly expose their internal corruption and desperation. Turns out, when corporations are under severe financial strain, the desperation at the top often trickles down, compelling local management to engage in desperate and illegal measures, even if it means lying to their own employees and state regulators. That's the verdict on today's case. Drop your thoughts in the comments. Was justice served? Make sure to subscribe so you never miss a filing.